Good afternoon, everyone. It's a little disconcerting because hopefully you can see us, but we can't see you. Welcome to this webinar from DECA Chambers. I'm Andrew Warnock, and beside me is Lisa Dobie. And this morning we're going to be speaking about the report of the independent inquiry into the child sexual abuse with specific reference to civil litigation. I will hand over to Lisa to begin the webinar.
Good afternoon, everyone. I hope you're all seeing our slides. You should have an introductory slide which is up. What we've got on our laptop is slightly different from what we have on the screen in front of us. So please do use the chat if you are unable to see the slides, or if you're having any functional issues, please do let us know, because as I say, and as Andrew said, we can't see you at this end. So yes, welcome to today's webinar. What we propose to do is I'm going to take you through an introduction into the report and its remit. Andrew is then going to look at the limitation issue, and I'm going to have a look at the redress scheme. What we would invite you to do is, in the process of the webinar, if you have any questions or queries, please do feel free to use the chat facility, which you'll see in the taskbar of the Zoom app. Equally, there will be an opportunity for questions at the end, but myself and Andrew will be looking at the chat and we'll try to answer things as we go along, or we can reserve things until the end. So that would be great. Okay, so the timeline of the inquiry, quite long-standing. It was originally announced in July 2014 and reconstituted in February 2015. The final report was presented to Parliament on the 20th of October 2022. I'm sure some of you that practice in this area will have also been interested in the interim report in 2018 and various recommendations which have been coming out throughout the life of the report. The remit was a broad one. Consider the extent to which state and non-state institutions have failed in their duty of care to protect children from sexual abuse and exploitation, to consider the extent to which those failings have since been addressed, to identify further action needed to address any failings identified, to consider the steps which it is necessary for state and non-state institutions to take in order to protect children from such abuse in future, and to publish a report with recommendations. And of course, we're now at the stage where that report with the recommendations, 20 of them, has been published. The work of the inquiry was intense. There have been 15 investigations, an interim report of the inquiry, 41 other reports and publications, and a final report which contains 20 recommendations. Those 20 recommendations have been summarised for you at the end of these slides, and we'll make the slides available for you if you would like a copy. The 20 recommendations made in the final report of October 22 complement 87 earlier recommendations which were made during the life of the inquiry, some of which are repeated. I believe about 6 were repeated. The Truth Project, this has been a really important part of the inquiry, to give those victims and survivors a voice, to speak in a non-confrontational way, openly about their experiences of the civil justice system, criminal justice system, their experiences as victims and as survivors. And there were some common themes to that which they reported. The initial barriers to reporting the sexual abuse in the first instance and since, because a number of these, a great number, are historical. Not being listened to at the time and or since, whether that's the people they reported it to, the police, and or not being believed when it's taken to, when the criminal justice system is accessed or the civil justice system is accessed. The shame of that disclosure, fear of the consequences, and in relation to the abuse itself, being too young at the time to recognise that the treatment of them was abusive. In terms of how this translates to the civil justice system, how do those victims and survivors, what have they reported in terms of what they want from the civil justice system? And again, there are some common themes. But some claimants want different redress from other claimants, as one would expect. So some would say, I want justice, but not necessarily being able to formulate what justice is for them. Others want compensation or a combination. For others, the money is absolutely not what they want, and they want the apology, the acknowledgement, or some form of reassurance that things will be different in the future. Others have said, I just want an apology. I was hoping that I'd get some recognition for what had happened to me, hoping that I would be vindicated for being called a liar all these years and that finally someone would listen to me. Others say a day in court, and is a day in court a civil contested trial? Sometimes it isn't, sometimes it's just the acknowledgement of having some formal system where their voice is heard. And again, there are common themes through the Truth Project about their experiences, and really this drives the title to today's seminar, that the civil justice system is recognised as not providing adequate redress for a number of the claimants. So the shortcomings that were identified, difficulties in accessing representation, and we see this, and I'm sure Andrew will be touching upon it, on the issue of limitation, for instance, where there are limitation issues, there are barriers both in getting representation because of the prospects of success, so that there is then access to barriers with the representation, funding, the system itself being adversarial, and re-traumatising for claimants. The slow process, the inquiry has recognised in its lifetime from 2015 to 22 that the process is less slow than it used to be, but overall it remains a slow process. The court cannot offer an apology. Very often it doesn't offer acknowledgement or any form of reassurance as to future risks of abuse or what steps have been taken to reduce or lower that risk. The difficulty of proof, especially when we're dealing with historical cases of sexual abuse, and documents not being available, witnesses not being available, and often it's only the claimant that is able to give their account and prove their case. Solvency of defendants, identifying insurers, that's something that we'll touch upon that's been identified during the lifetime of the inquiry and recommendations made. But we know even as defendants recognise, identifying the correct insurer for the correct period of time can be quite complex, and that is equally as complex for claimants when they're identifying whether or not it's possible and worthwhile pursuing the civil claim. Pre-action protocols. Those of us that practice in personal injury generally know full and well about the pre-action protocol for personal injury claims. It's that pre-action protocol which applies to cases of sexual abuse. There has been much discussion within the life of the inquiry about whether there should be a dedicated pre-action protocol. The recommendation, which was in 2018, was that there ought to be a pre-action protocol. This is being consulted upon, but there is no outcome to that as yet. And I believe, if I just go to my dates for that, that it was first canvassed in 2016, so we're talking 6 years ago, that was first canvassed. There was an original consultation, and really what it's looking at is earlier resolution, apologies, and some form of acknowledgement. In September 2019, it was recommended that the local that the LGA and ABI get together to discuss a pre-action protocol and consult on its feasibility and its content. The ABI did manage to publish in August 2021, and we're expecting the LGA consultation to be published shortly. So watch that space. And then the previous recommendation with regard to insurers was that there ought to be a register of public liability insurers. Again, this is a matter under consideration. As I understand it, the current position is that in May 2022, the Ministry of Justice has reported that there have been a number of pressures in publishing anything in relation to the list of insurers, but some of those pressures have since eased, and we are expecting a feasibility study in due course. In addition to the pre-action protocols and the list of insurers, there has also been consultation and recommendations surrounding the codes of practice. The ABI have published their code of practice to deal with handling of the claims in a sensitive way, that the limitation defence should be taken only in exceptional circumstances, and that consent has to be obtained for that defence to be taken. Where possible, single joint experts should be considered, and apologies, acknowledgement and redress and support should be provided where possible. During the consultation process, those involved in the inquiry did hear from some insurers about their practices in this area. Zurich assisted with the inquiry, and they currently have their own code of practice quite similar to this, and so that seems to be lifted from the information provided by Zurich to the inquiry.
EIG do as well.
Yes, yeah. So this is not entirely new. And again, the local government published in June 2022 along similar lines, as you can see there. So that's what's been happening in the life of the inquiry. But following the publication in October 22 and the recommendations, Andrew and I thought that two really interesting aspects of that for purposes of civil litigation were limitation and the redress scheme. So I will hand over to Andrew, who's going to talk about limitation.
As Lisa said, in relation to limitation, that was considered to be one of the, and is considered to be one of the major barriers to claimants who bring civil proceedings. You will all be familiar with Section 33 of the Limitation Act. Why are we considering Section 33? Well, because you will all also be familiar with Sections 11 and Section 14 of the Act, which say that the primary limitation period for personal injury claims is 3 years. That can be 3 years from the date of knowledge, but as you will all know, in case law, rather puts a heavy presumption that if you have been sexually abused, you're likely to have knowledge of the wrongfulness of that at or about the time it occurs. And of course, limitation periods are extended in the case of children until they reach the age of their majority, starting to run at that point. But as we all know, many cases involving non-recent abuse are brought by people well into their adulthood, sometimes quite late into their adulthood. And therefore, Section 33 is of huge importance in the cases, and that's the discretionary time limit extension if it appears to the court that it would be equitable to allow the action to proceed once one's balanced the prejudice that the plaintiff would suffer and the prejudice that the defendant would suffer. Prejudice to the claimant if the limitation period is not extended, prejudice to the defendant if it is. And you will all also be familiar with the various factors which the court is required to take into account, the so-called statutory checklist, in particular the length of and importantly the reasons for the delay, also importantly the extent to which the evidence adduced is likely to be less cogent because of the delay, conduct after the action arose, which in my experience is rarely an important feature, but that's to do with not conduct involving the cause of action itself, but conduct as to how the defendant acted, usually once put on notice of the cause of action. Any periods in which the claimant was under a disability, and the extent to which the claimant sought and then acted on expert advice. Now, going back a little to Kane and Francis, which wasn't a sexual abuse case, but it's a personal injury case, Lady Justice Janet Smith summed it all up really by saying that in the exercise of the discretion, the basic question to be asked is whether it is fair and just in all the circumstances to expect the defendant to meet this claim on the merits, notwithstanding the delay in the commencement. Now, there then followed a period where it seemed that the courts may be going to take a more stricter line in favour of applying limitation periods. And perhaps the high watermark of that was a case of RE and GE back in 2015. It was a claim for sexual abuse brought by a claimant against a relative. And there, Lord Justice Lewison said that whether a fair trial can still take place is undoubtedly a very important question. However, it seems to me that if a fair trial cannot take place, it is very unlikely to be equitable to expect the defendant to have to meet the claim. But if a fair trial can take place, that is by no means the end of the matter. In other words, I would regard the possibility of a fair trial as being a necessary, but not a sufficient condition for the disapplication of the limitation period. And that, along with other comments in the case, stressing how limitation acts were statutes of peace and how it was important to recognise the policy which underlay them, which was that claims should be dealt with reasonably expeditiously and not left to hang over people, was thought to potentially herald a more, a less generous approach to extensions of the period under Section 33. However, in Carroll and the Chief Constable of Greater Manchester Police, Sir Terence Etherton, then Master of the Rolls, rode back slightly from that and said the prospects of a fair trial are important and the Limitation Acts are designed to protect defendants from the injustice of having to fight stale claims, especially when any witnesses the defendant might have been able to rely on are not available or have no recollection, and there are no documents to assist the court in deciding what was done or not done and why. It is therefore particularly relevant whether and to what extent the defendant's ability to defend the claim has been prejudiced by the lapse of time because of the absence of relevant witnesses and documents. So there we see the focus very much back again on the question of whether a fair trial is possible and whether the defendant has been prejudiced. In DSN and Blackpool Football Club last year, this was a case where the claim brought by DSN against the football club for abuse he suffered at the hands of a volunteer failed, in fact, on vicarious liability grounds in the Court of Appeal. But the Court of Appeal upheld that the judge had been right to extend or entitled to extend the limitation period for bringing the claim. And in this case, Lord Justice Stuart Smith said, perhaps echoing what was said in RE and GE, but putting a new focus on it in relation to Section 33, he said, furthermore, although the policy reasons that have caused Parliament to establish limitation periods are well known, and as I say, those have been emphasised by the Court of Appeal in RE and GE, so too are those that cause Parliament to temper the harshness of fixed point cut-offs by a series of statutory provisions from 1963 onwards, including Section 33. Thus, for example, a finding that a claimant could not have brought an action before they did is likely to attract significant weight, particularly if that inability is attributable to the tort that is to be the subject of the action. Precisely how much weight is to be attributed to different features of a case is quintessentially a matter for the judge in the exercise of their discretion. And I would draw two things out of that statement. Firstly, the court seems to have been putting a lot of emphasis on the Carroll approach as opposed to the RE and GE approach. In other words, the real focus is on the fairness of a trial. But secondly, a very strong signal from the Court of Appeal that at the end of the day, this is a matter for a judge's discretion. And certainly this constitution of the Court of Appeal has signalled that they would not be inclined to interfere with the exercise of that discretion, at least generally. As I said, and Lisa said, IICSA said that this was one of the most challenging legal issues victims and survivors face, and they identified it as being a barrier at 3 stages. First of all, taking on claims. Secondly, when negotiating settlement and valuing claims. And thirdly, of course, if the case gets that far, the trial itself. And interestingly, from the point of view of survivors and victims, concern about requiring reasons for the delay was found by some of them to be the single most traumatic feature of this type of litigation, having all those things raked over and gone into. So IICSA have come up with a recommendation to remove the limitation defence in claims brought by victims and survivors of child sexual abuse in respect of their abuse. But they propose to balance that by providing for express protection of the right to a fair trial, with the burden falling on a defendant to show that a fair trial is not possible. In relation to the burden, strictly the burden under Section 33 to show that it is equitable to disapply the limitation period falls on a claimant, although there are many statements in the case law to the effect that it is not a particularly heavy burden, and indeed that that type of case usually wouldn't turn on the burden of proof. IICSA proposed that the legislation would not allow the reopening of claims in 2 circumstances. The first is where a claim has been settled by agreement, so even though limitation and indeed the prospects of a limitation defence succeeding may have been a significant factor in negotiating a settlement, those settlements will not be capable of being reopened. And secondly, where a claim had been dismissed by the court. It does have the proposal does therefore leave open the possibility in that in the cases perhaps where defendants thought they were strongest and didn't make any offer of settlement, or the case didn't settle and it didn't go to court, those cases could still be brought again under the IICSA proposal. The new provision would not apply to claims brought by victims and survivors' estates, the focus very much being on people who are still living with the consequences of childhood sexual abuse. The question we raise is, given where the law has ended up again on limitation and Section 33, which essentially under Section 33 seems to come back in the vast majority of cases to whether a fair trial is possible, whether the proposed form would actually make any significant difference to where we are. And indeed, particularly where one has an insured defendant who's a member of the ABI. The ABI Code of Practice, as Lisa has mentioned, specifically says that limitation should only be taken as a defence exceptionally. And although there's no definition of exceptional it's clear from the paragraphs which deal with the subject in the ABI code that by exceptional is really meant cases where a fair trial isn't possible. Those would be the only cases where a limitation defence would still be taken for an insured client. The local government code isn't so explicit on the question of what would be exceptional, although it does make reference back to the ABI code. And it is perhaps also just worth diverting from this topic slightly, mentioning another difference from the local government code from the ABI one, is that, as Lisa mentioned, the ABI code says that a defence that a claimant consented to the alleged abuse should only be taken exceptionally, whereas the local government code does not say anything about consent. So the first question we raise is, would the proposed reform really make any significant difference? And I have to say I'm slightly doubtful that in the terms it's put, that it really would. If it will make a difference, might it in fact have unintended consequences? Now, much would depend on how it was legislated, but for instance, to simply take away the limitation defence and replace it with a test of what constitutes a fair trial, on the face of it, might result in cases which wouldn't be time-barred under the current regime becoming time-barred, because it is conceivable that one could have a case, perhaps with a patient, for instance, who's under a claimant who's under a disability, where under the current regime, limitation would never have run. But actually, it's quite impossible to have a fair trial. Is that claimant intended to be worse off under this proposal? Or indeed, even a case where abuse happened very young and it might not be possible to have a fair trial before someone is aged 18. One would have to see how the legislation would address that. It would have to protect, presumably, cases like that from being covered by it. Might it have other unintended consequences, as Lewis and LJ hinted at in the RE and GE case? It is in theory possible under Section 33 to have the limitation period extended even if a fair trial isn't possible, because it may be that the reasons for the claimant's delay actually outweigh the prejudice caused to the defendant. And that may raise questions as to, well, when is a trial actually fair or unfair? In the current Balancing Act, sometimes it doesn't take very much in a case of long delay without a good reason for a judge to conclude that a trial would not be fair. But what would it be under what would the test be under the proposed legislation? And again, an unintended consequence, but perhaps a foreseeable one of the proposed amendment, may be lots of satellite litigation about what the new provision would mean. Will it happen? Well, a read through the IICSA's report wouldn't fill one with a huge amount of confidence that it would. Many reforms were proposed and recommendations made in the interim reports. Most of them have progressed not at all. So reforms on a regulation, for instance, of professionals involved in teaching children have not happened. Reforms in relation to completely prohibiting the use of physical restraint in certain settings have not happened. I could go on, the list is a long one. And looking at the potential problems with this proposed amendment, I do question whether or not this one might ever happen. It's reform of the Limitation Act in cases of child sexual abuse was previously considered but rejected by the Law Commission in 2001. What we are told by the Ministry of Justice or about the Ministry of Justice in the IICSA report is that it says it is now willing to consider the merits of such a change. And I might just at this point mention, we were asked a question in advance of the seminar as to whether the limitation period under the Human Rights Act might be reformed. There's certainly nothing in the IICSA report which would suggest any reform to limitation under the Human Rights Act. As many of you will know, the government launched a consultation on replacing the Human Rights Act with a Bill of Rights that was dropped under the brief period of the Truss administration, but has now come back to life again under the current administration. But there are no proposals in that bill to touch limitation under the Human Rights Act. And limitation under the Human Rights Act, I think, raises very different considerations. It's a shorter limitation period, although questions such as a fair trial can be and are relevant. There are also issues about a desire to see litigation against public authorities under the Human Rights Act dealt with fairly expeditiously. So I think it's probably unlikely we would see any change to the limitation period under the Human Rights Act. And I query whether we'll actually see a change under Section 33 as well. But we might, and if we do, I'm not sure it will make a huge amount of difference from where we are. Lisa.
So I'm going to speak about a further recommendation, which is in relation to a redress scheme. But before I touch upon the redress scheme, it's probably worth looking at redress in all of its guises. So I've got a slide here in relation to apologies. During the course of the inquiry, there was, it's clear that from the Compensation Act 2006, Section 2 currently provides that an apology, offer of treatment or other redress does not of itself amount to admission of negligence. However, during the course of the inquiry, it became apparent that would-be defendants, institutions and or insurers were not confident in giving apologies in all cases, in case it led to an inference of liability or it might render insurance void. And reference was made to the fact that the Compensation Act 2006 referred to apologies made in claims brought for negligence or breach of statutory duty. And of course, very often in historical sexual abuse cases, they're brought at common law, but on the basis of vicarious liability. And there was some concern that because that vicarious liability wasn't expressly stated, would it be caught by the Compensation Act 2006? Now, the recommendation, which was made in September 2019, was for an amendment to the Compensation Act 2006 to make this clear. An amendment hasn't been forthcoming. There is a consultation on it. However, I believe it was spring 2020, the government did respond to say that the Compensation Act 2006 wasn't intended to be limited to negligence and breaches of statutory duty. It was meant to cover the range of common law causes of action, but as of yet there has been no amendment to the Compensation Act, and so some insurers and would-be defendants and institutions are not entirely confident in relation to that, but it has been stressed by government that it should capture all common law claims. The Criminal Injuries Compensation Scheme, as you will be aware, some victims and survivors will be signposted, and now certainly ought to be signposted by the police to the various compensation schemes, one of which is the CICS. But there are, as ever with any scheme, there are hurdles in relation to that, and I've summarised them on this slide here. This scheme applies to victims of violent crime, so it doesn't include what we now see as a growing concern in relation to sexual abuse and sexual assault, which is the online abuse of children, and that wouldn't be caught by the violent crime requirement under the CICS. It is intended as a scheme of last resort, and it is tariff-based, and it excludes applicants with unspent criminal convictions for offences resulting in certain sentences or orders. And as the inquiry explored during the course of the inquiry, it explored the fact that a number of the victims and survivors will often be caught up in a criminal activity, not in every case, but in some cases, and that will be linked to the abuse itself, and they wanted to avoid those victims and survivors being pushed out of the CICS scheme. It also only has a time limit of 2 years, which is short, and where the abuse is first reported to the police when the applicant is a child, the claim can then be made up until the applicant's 20th birthday, so as we recognise 2 years after they reach majority. And that time limit can be extended in exceptional circumstances. The recommendation has been made to modify this in 3 ways. So it ought to be extended to cover online abuse, so a modification of the requirement for it to be a violent crime. There would be no automatic rejection for those with criminal convictions, where the criminal conviction is seen to be linked to the childhood sexual abuse of the applicant. And a longer primary time limit of 7 years, or 7 years from the age of majority, has been recommended, whilst also retaining the ability to extend in exceptional circumstances. And again, that's just the recommendation from the October 2022 application. So the redress schemes in relation to civil justice, what is being sought is a non-adversarial process by which financial redress and potentially other forms of redress may be provided to applicants. The adversarial nature of the civil justice system was a theme of those that gave evidence to the inquiry as a problem and a reason why the civil courts were a last resort for them, because it was incredibly stressful and re-traumatising. It will be distinguished from a litigation settlement scheme, which may be used to compensate groups of claimants who have initiated civil claims. So it will be individuals bringing an application to the redress scheme. It's envisioned that it will be on paper, albeit with a need for psychiatric reports in a number of cases, but that will be brought on an individual basis to the national scheme. And it's important to note that it sits outside of the civil justice system, so it will be an additional option for those victims and survivors who do not wish to go down the CICS route or do not wish to resort to civil litigation. This would be an additional scheme, something that they can use to gain financial redress, or, as is envisaged and hoped by the recommendations, things such as apologies and acknowledgements and potentially treatment. We're not wholly unfamiliar with redress schemes. There are a number of existing examples, Scotland most recently in 2021, and Northern Ireland have a scheme, Jersey, Ireland, Australia, Lambeth. They're all slightly different. So the Scottish scheme is based on a compensation would be via a set amount, and then that can be increased in certain circumstances subject to evidence. Northern Ireland is along a similar scheme. Australia has a scheme whereby the financial redress is calculated according to the type of abuse. Some of them are on a point system, so certain criteria have to be satisfied for the redress to be achieved. Lambeth and Manchester are slightly different, because rather than a national scheme, it's looking at a particular group of victims and survivors. And so very often the compensation or financial redress in those schemes is comparable to that which would be achieved in a civil litigation, but that's not necessarily envisioned for this redress scheme. There's no one size fits all. And as you would see from the recommendations which have been made by IICSA, that what they have provided is a number of recommendations and aims for the redress scheme, but the detail has been left to the government. And as a consequence of that, you'll see if you read any of the interim reports or the comments made by those representing the insurance industry, that some are have yet to comment upon how it would really operate, whether they would want to be part of such a scheme, and really seeing how this would work out in reality is quite difficult for them because they don't have the detail as yet. So the recommendations is it would be an alternative to civil litigation and the criminal compensation. It's important to note that IICSA recognises that there should be no double recovery. So if, for instance, somebody has recovered redress under the CICS, that would be deducted from any award which was going to be compensated under the civil redress scheme. There are a number of recommended core elements. So the child sexual abuse must have occurred in England or Wales. There must be a clear connection to a state or non-state institutions in England and Wales. They give the example within the paper that doesn't mean that the abuse has to have occurred at an institution, but there just needs to be some link to it. So whether it was being if somebody's being cared for by the state, then of course that is a clear example which is cited within the report. But there will be other instances where they were being cared for in some way, or being funded by, or it's been at the institution itself. So at the moment, that's quite it encompasses quite a broad number of potential victims and survivors. The abuse must have took place before the scheme's establishment, so it isn't yet established, it's not yet decided, so all potential claims up to now and the commencement of any scheme, if and when it comes into force. The deduction of any previous awards, which I mentioned earlier, which is the point about double recovery. And what's envisaged loosely is a two-tier payment system, so there would be a flat rate recognition payment. Again, the detail on this is vague, whether one would assume that's just the same amount yet to be fixed across the board, with the option then to apply for a second tier payment requiring more detail. One would envisage, if it's envisaged that the first fixed flat rate would be a paper-based system, one would envisage that the second tier would also be a paper-based system. Whether it's more in-depth psychiatric reports, we know not. Again, that detail is left for government to decide. And there would be an exclusion where a civil claim has been rejected for non-limitation reasons. If it has been excluded for limitation reasons, then they do have the option to apply through the scheme, which is attempting to deal with the mischief that Andrew has just been speaking about and the inherent difficulty with limitation in these cases. Levels of award, they should be sufficient to recognise the experiences, but may not be as high as awards involved in civil claims. So I mentioned earlier the Lambeth scheme, for instance, which seeks to provide financial redress comparable to the civil justice system. The indication here is that the levels of award may not reach that level, but again, the detail is yet to be decided. It's going to be difficult to come up with a level of award that can meet a large national scheme and go anywhere near to providing adequate compensation. So it's recognised here that it may well be less than that which would be awarded in a civil court. And as I said previously, the details are to be worked out by government. What I haven't dealt with on these slides is the issue of funding. What's envisaged is that it will be funded by local and central government with the optional payments, voluntary payments from the institutions involved. Again, the detail of that is to be decided by governments. There is a lot to be worked out. There is some scepticism about how some victims and survivors may feel about that, because what you see through the Truth Project and what some victims and survivors were reporting is that they want to see the institutions pay, and if it's being paid out of local and central government funds, then no doubt there will be some victims that feel that the institution hasn't paid. But of course that will then feed back into how much the institutions are required to contribute and in what context. I provided a summary of all of the recommendations at the end of the slides. There are 20 of them in total, so you can read through those, and if you have any questions about them, then please do ask. Before, I'll just go to skip back in terms of and go back to the redress scheme. In terms of the pros and cons of the redress scheme, I can see that there are some great advantages to having a redress scheme. It does provide options for those victims and survivors where the CICS scheme isn't working, or where they don't want to resort to civil litigation. You can see from the figures within the inquiry that actually it's a very small percentage of victims and survivors that do end up bringing a civil claim, and payments are not made out in every case, far from it. And so it's not something that the vast majority embark upon, and this would provide a further option for them that may well be beneficial to all involved, because it may result in what it is hoped it would result in is a quicker process, a process where costs are not going to be as high because it's going to be on paper, non-adversarial. And so in some ways it would have its advantages for would-be defendants also. Also, the flexibility of the scheme to allow for the other forms of redress that we've seen identified, such as apologies, acknowledgement, changes to the system. We're told that, those are the things that the victims and survivors often want more than financial compensation. But in terms of the potential disadvantages to the system, it's really about how we see this working out in reality. What would it actually look like? How will it be funded? So we're told local and central government, our local governments don't have broad shoulders for additional funding at the moment. And so how will that be worked out, and will it satisfy those victims and survivors if the institutions are not directly paying? So it's watch this space. We know that the detail still has to be worked out, and that is likely to take some significant period of time. So we will wait to see if and when the redress scheme comes into force. If anybody has any questions, I'm not sure if there are any in the chat or Q&As. No. There are no questions at the moment, but if anybody does have any questions, please do pose one in the chat or the questions and answers, or you have the contact details for myself and Andrew. If you have any questions following today's webinar, then we would be very happy to help. I can't see anybody furiously typing. So we've taken up 50 minutes of your time. We'll leave it there.
Thank you very much, everyone. Have a good afternoon.
Thank you. Good afternoon.